and we will start the presentation. So we are 5 minutes after 11 o'clock, 10 o'clock in Brussels. Good morning, everyone. Thanks for participating to this webinar, the webinar about the impact of Brexit on the GDPR obligations for Romanian and Moldovan companies. The presentation will be done by Jane Murphy. She's the founder and the chairman of the board of EDPO. EDPO stands for European Data Protection Office. And the second speaker is Romane Geurts, data protection representative also from EDPO. I would like to ask everyone during the presentation, if you have questions, to write it down in the chat box, to mute yourself, and by this I give the floor to Jane. Please, Jane.
Great, thank you so much. So welcome everybody. We're very, very happy to be here today. So as was just said, we're going to talk about Brexit, the impact of Brexit on your company obligations and what changes and what you need to do. So, so yes, I'm Jane Murphy. I'm the founder of EDPO. I'm a corporate lawyer and a GDPR lawyer, and based in Brussels, where EDPO is European representative. And we also have a separate company that's EDPO UK, based in London, to do UK representative for the UK GDPR. I'll briefly ask my colleague Romane to introduce herself, please.
Thank you, Jane. Yes, nice to meet you, everyone. Thank you for being here. So my name is Romane, and I have a legal degree from UC Louvain in Belgium. I graduated, not so long ago, and I specialized in GDPR and data protection, and I'm also CIPPE certified. And at EDPO, I act as an account manager, and I also work for EDPO UK. So yeah, both companies.
Great. Okay, so let's get started. So Romane has the lead on the slides. So let's switch to the agenda.
Yep, there we go.
So we're going to separate this in 5 steps, and feel free to ask any questions as we go along. We're going to check the chat box, so just shoot your questions whenever you have them. We'll also keep a question period for afterwards, so no words. Excuse me. So the important thing is that we want to make this as practical as possible. So anytime you have specific questions about your specific case, I think this is the whole point of the seminars, to make sure that everything is covered and that you get the answers to your question. So the first thing we're going to do is look at what are the impacts of on your obligations with respect to Brexit. Then we're going to look at what we call the forgotten obligation, and that has to do with appointing a representative. We're going to go through, what is the representative? Do you have to appoint one? What are the exceptions that maybe you don't have to appoint one? So we're going to go through that. And then we're going to see how you can avoid to breach the EU rules in light of the data transfers, between the EU and the UK, and what all this talk is about. What is an adequacy decision, if it's going to come, and when, and what does that imply for your company? Then we're going to try to give you practical tips to put in place for the 30 June deadline, which is very close from now. So in 2 weeks' time, let's see what happens. And then questions, as mentioned earlier. Okay, so let's get started. So what does Brexit mean for your company? What's the impact on your obligations? What do you need to do now or later, or not do at all? So first, it's important to look at what is the current situation with respect to Brexit. So we all know that 31 January 2020, there was this withdrawal agreement, and that was followed by a transition period. And that transition period was until the 31st of December 2020. And that concerned all GDPR obligations. So business went on as usual. So everything concerning GDPR continued as usual. So on 24th of December 2020, excuse me, a trade and cooperation agreement was signed between the UK and the EU. And there was a new transition period until the 30th of June. However, this second transition period only concerned data transfers. So all the rest of the obligations of the GDPR and of the UK GDPR continued as from the 1st of January, except for this obligation with respect to data transfers. And that means that all transfer between the EU and the UK continued as usual. So the EU a long time ago, the UK a long time ago had already decided that any transfer of data, personal data, from the UK to the EU would be unrestricted. That means no special measures need to be put in place. Transfer as usual. However, the EU said towards the UK, okay, for now, you can continue to transfer personal data to the UK if you're in the EU, but only if you put in some, for now, it's okay, as if it was under the GDPR. But after the 30th of June, if there's no adequacy decision, you may have to put in some specific measures. So it's status quo until 2 weeks from now. And so what does that mean in practice? So since the 1st of January, of course, we know the UK is no longer part of the EU, so it's a third country. So for Moldovan companies, whereas the UK was part of the EU before, now it has to treat the UK as a third country, just like the EU companies have to do that too. The UK GDPR came into effect. That's a really important thing to know, because it's kind of like people are saying, well, does it still apply? Does it not apply? It's actually a new GDPR. So it's a UK GDPR. That's exactly what it's called. And it's basically a copy paste of the EU GDPR. So the same principles and obligations. There are a few tweaks here and there that have been adapted to the UK, but in all essence, excuse me, all the rights and obligations stay the same, and we'll see what that entails for your companies. So again, transfers personal data from the UK to the EU already recognized by the UK, and transfers from the EU to the UK, for now, they continue until the Commission makes a decision. So let's continue. So what are the most common misunderstandings about this transition period? So as I mentioned, as from the 1st of January, non-UK companies that do business with the UK have to comply with UK GDPR obligations. And one of them is this forgotten obligation to appoint a UK representative. Now, Romane's going to go more in detail on what that entails, but this is really something that you have to keep in mind, because the transition period for the data transfers does not affect that obligation that you have to appoint a UK representative. And a lot of people that we speak to, unfortunately, think that we're waiting on this adequacy decision to see what happens before we make any decision on, do we need to appoint a UK representative? So you should not wait. This is now, it applies now, and there are sanctions.
No?
Hello? Somebody's asking a question? No?
I don't think so.
I heard somebody.
Else. Yeah.
All right. Okay. All right, let's move on.
Yes, sorry. Oh, there we go.
So what's the impact of Brexit for Romanian companies? So it has two main effects. The first one is this forgotten obligation is the UK representative. So Romanian companies and all other companies in Europe that don't have an establishment in the UK have to, and if they offer products or services, even for free, most likely have to appoint a representative in the UK. So this is, it's not towards UK citizens, it's people located in the UK, and we'll give you really practical examples to see, do you fall under this obligation? And again, the international transfer. So those two main obligations. Okay, let's see now for Moldovan companies. Actually, this obligation for representative is a double one from Moldovan companies. So if you're located in Moldova and you do business with the UK and the EU, so now it's considered as, two separate countries, if you like, the EU bloc and the UK bloc. And if you offer products or services to both these blocs, then you probably need two UK representatives. So Romane again will go through the details with you. International transfers, nothing really changes for Moldovan companies because both UK companies and EU companies are considered, located in third countries as per Moldova. Look at your national data transfer laws and obligations to see how you can transfer personal data from Moldova to the UK and the EU. Unfortunately, we're not in Moldovan law, so we can't give you more detail on that. But check at your local national level what those obligations are. All right. Okay, Romane is going to take it from here to explain what is this forgotten obligation.
Yes, thank you. So as I said, what's the data protection representative? Well, the representative has three main functions pursuant to the EU GDPR and the UK GDPR. So as Jane said, it's really the same thing. It's a copy paste. So it's the same article and they have the same obligations in both those blocks, as we said. So the representative acts, first of all, as a point of contact between data subjects and the company, so individuals. It acts also as a point of contact for data protection authorities in Europe or in the UK. And the third obligation is that the representative has to keep a copy of your record of processing activities. Now, practically speaking, what does that mean? So acting as a point of contact means that the contact details of your representative have to appear somewhere on your website and preferably on your privacy policy. It's where most of the information regarding privacy and data are located. So it's best to have them on your privacy policy so that the individuals or the data protection authorities can easily contact the representative, because they can contact the representative if they want to, instead of contacting the company directly. So it can be anything. It can be a data subject, so an individual who wants to exercise their rights pursuant to the UK or EU GDPR. It can be a data protection authority leading an investigation, really anything. And so about the record of processing activities, if you're part of the EU, you might already be familiar with it. It's again, the same obligation exists in the EU GDPR, and now it exists in the UK GDPR. It's basically a summary of your processing activities regarding the EU personal data or the UK personal data, depending on the situation you're in. But it's a simple Excel sheet usually that contains basic information on the processing activities. So, and then the representative has to have a copy of it. Now, so the representative must be based in the UK for UK representation purposes. and in one of the EU countries for EU representation purposes. Now, yeah, so the UK, obviously it's only one country, so the UK must be based there. But in the EU, the representative only has to be located in one of the EU countries, and it's valid for the whole UK, the whole EU/EEA area. So you have to appoint your representative in a country where you have data subjects. So you can't just pick where you want your representative to be, but if you have data subjects all over Europe, then you can, but it has to be where you have at least one data subject. And also the representative must be appointed by a mandate agreement.
Romane, can I just specify one little thing? Data subjects, it's a technical term in GDPR for those who are not familiar with that, is where you have people of whom you're collecting data. So it could be a customer, a client, or a candidate applying for a job at your company or something. So just basically an individual located in Europe.
Yes, thank you. That's actually a good idea to specify. So now the big question, do you actually need to appoint a representative? There's two conditions. So let's start with the UK. You must appoint a representative in the UK if your company, and in this case, it can be your EU company, so Romanian or Moldovan company, if you don't have an establishment there. And the second condition is if you provide goods or services to people located in the UK, or if you monitor the behavior. Now, let's dive into this because it's not super clear at first sight. So first of all, the first condition is if you don't have an establishment in the UK. Well, establishment can be anything really that's related to having a presence in the UK in this case. So it can be a branch, a subsidiary, a sales office, anything. If you do have a presence in the UK, that means that you have an establishment and you don't need a UK representative. Not having an establishment mean you don't have any presence there. That's so you don't have any, your activities in the UK are not inextricably linked with the processing that you do in your home country. So yeah, it's really this idea of the presence there. If you don't, then you need, a representative. Now, the second condition, if you provide goods or services to people in the UK, and it can be for free, so it does not imply payment, especially payment. And if you monitor the behavior, the monitoring means any type of tracking or profiling that you can do. Let's say on a website, if you, for example, if you track visitors on your website or your sales orders or anything, then that's already considered as monitoring, and it implies that you may need a representative in the UK. Now, let's switch to EU. Same conditions, same thing, as we said before, same article. So you must appoint a representative in the EU if you don't have an establishment there, and if you provide goods or services to people there, or if you monitor the behavior. So as you can see here, Moldovan companies are in, and Jane said that already, but Moldovan companies may need to appoint both representatives because if you don't have an establishment in the EU and in the UK, that means you need both. Whereas Romanian companies only need to maybe appoint a UK representative because as Romania is already part of the EU representative is not necessary. So that's for the theoretical part, and we put some examples there to kind of help you see what if you're in one of these situations, it might help. So let's say if you're a company in Moldova that exports flowers to the UK or the EU, exporting, of course, we mean it can be anything, selling your flowers to customers or to companies. As you can see, it can be B2C or B2B. Exporting is basically processing the personal data of the people you're exporting new products to. So
I'm sorry to interrupt, because this is exactly the question that we just got now in our chat box. Does provision of goods or services in the UK concern only private individuals or corporate clients as well?
Yeah, it's for both B2C or B2B, because so the basic of this is that you have to appoint a representative when you process personal data of people located in the EU or UK. Well, if you're selling to companies, unless you're only you only have contact with let's say generic addresses, only like an info@address, then you're still processing personal data of, for example, the employees of the company you're working with, and all these type of personal data. So it can work for both B2C and B2B. So next example, if you're a company in Brasov, I hope I'm pronouncing all these names right, Brasov, that sells bike parts to UK companies or manufacturers. Here we took out the B2C part. It's only B2B. You see that, for example, this company sells only to companies. So, and it's still products, and it works, still falls within the scope of that Article 27. So still needs a representative. Now, if you're a charity organization in Romania or Moldova, anywhere really, and if you have contributors in the UK, for example, well, we have the case here of a non-profit organization, which also falls within the scope of the UK GDPR and even the EU GDPR for Moldovan companies. So again, you may need to appoint a representative. Next example is your company in Chisinau that provides IT consultancy services to EU or UK startups. So here we're in the case of providing services, not products, but it still works. And it's for B2B because it, as you can say, the company provides its services to other startups or companies. Still falls within the scope. And then last example is your law firm in Bucharest that provides legal services to UK companies or individuals. Here we have B2B, B2C, still works the same. Law firm, you can think that it's not part of the, it's not within the scope, but it is because they're processing personal data of people in the UK in this case. So they do need to appoint a rep if they don't have an establishment there. So, and then next, yeah, okay, some exceptions. So there are some situations where you don't need to appoint a representative. Now, the first exception is if you're a public authority, so then you don't need a rep. Or the second exception is, of course, as we said many times, if you have an establishment in the UK and or in the EU, depending on the case. And the third exception is if you carry out processing activities only occasionally, on a small scale, and at low risk for individuals. Now, this third exception, it's all together. So the three part of this exception are cumulative, so it all works together. And the occasional part, we put it in bold there because it's not often very clear. Again, it's not defined by the GDPR, but it must be interpreted very strictly because occasional almost means if you're processing by accident. So that's really the idea of not having a regular processing. Now, it has nothing to do with the volume because you could be sending, let's say, a newsletter to people in the UK. For example, 2 people receive your newsletter once a month in the UK somewhere. Well, you're still processing personal data regularly on a regular basis because it's part of your business, it's part of what you do, and it's not occasional because you're doing it every month. No, whether it's a huge volume of individuals or not, that doesn't matter. So these are the exceptions. And then one quick question that we want to underline is your company at risk if you don't appoint a representative? Well, it's worth noting that very recently, the data protection, the Dutch Personal Data Authority, so it's called the AP, they announced, it was in May that they announced that they had imposed a fine of $525,000 on a company that's called locatefamily.com. So it's supposedly a Canadian company, but the AP did some investigation to really discover if they were actually based in Canada, but that's just a small detail. But the main reason for the fine was that they had no representative in the EU. And they also imposed a penalty of €20,000, I'm getting this wrong, it's euros, for every 2-week period during which they remained non-compliant. So yeah, up until the point where when they appointed a representative, they had €20,000 for every 2 weeks. So yeah, that's a huge fine. And it's kind of a wake-up call for companies, because it's the first to really, it's the first fine that's imposed on a company for having no representative for that specific obligation. And it's really important to realize that data protection authorities are taking this very seriously, and they're getting very serious with it. Here it's for the EU, but it can also be with the UK. I mean, the UK is gonna follow it's pretty sure that the UK is going to follow, because the ICO, which is the UK Data Protection Authority, they're very active also. So it shouldn't be long before they also, get in the game of fines. Yep. And back to you then, Jing, for the third.
Yes, thanks. Indeed. So how to avoid breaching the rules that we've just seen in order that you're adequate, that you're compliant with all these transfer rules, whether or not there's an adequacy decision. So let's first look, actually, do you really know whether or not you're transferring data to the UK? So this is a typical question sometimes that we run into with clients or potential clients, and they say, oh, this doesn't concern our company because you know what, we don't even export to the UK, so we don't even have to look into this. And we say, you know, you have to look really deep into all the processes in your company, everything that you're usually internally in terms of, you know, we'll look at these examples, but applications or software or cloud services or things like that, because you may be transferring personal data to the UK and not actually be aware of this. So for example, if you use the CRM, so it's a customer relationship management tool, or marketing software, well, if that's located in the UK, then you're transferring personal data to the UK because all your customer information is in the UK. So even if you're not exporting, but using that system that's based in the UK, all that data is being transferred there. So that's really something that we see quite often. So that's something to look into. Another example is if your customers pay online and they use an online application that's based in the UK, same thing, personal data related to financial data and things like that, to their orders, their email addresses, that is transferred to the UK. And if you transfer your customers' orders to manufacturers located in the UK, that was one of the examples also that the Romane used, whether it's B2B or B2C. If you're, for example, in Romania and you're having things manufactured or just parts manufactured or some, you know, some part of your activities is performed in the UK, but you're selling to somebody else or another company in the EU. However, you're transferring your orders with personal data of, you know, the name of the person and the email address and the delivery address. You're transferring that to the UK and they deliver directly to the EU. Although your relationship with your customers is directly in the EU, you're still transferring data via the UK for the purposes of your activities. So very important to have a deep dive look into your all your applications and all, you know, the data flows that you have. You really have to map that out. So what happens if you are transferring personal data to the UK? Well, this until now, until the 30th of June, it's fine. So you have nothing to do in terms of now. So that's great. So no headaches. However, 30th of June is really approaching quickly. What happens on the 1st of July then? Well, if the UK gets an adequacy decision from the EU, so the Romane will give you a little bit more detail on what all of this is about, this adequacy decision. Well, it's a decision that says, you know, basically it's okay, you can transfer to the UK. If this happens, and then on the 1st of July, excuse me, 1st of July, you can continue to transfer personal data from the EU to the UK, no problem, as you're doing at this moment. However, if as you know, 30th of June, there is no adequacy decision and there is no extension of this transition period. We don't expect that there will be, but we all know that in this Brexit saga, there have been last minute changes, you know, at like 2 to midnight or something. So there could be an extension, but we really do not expect that there will be one. So imagine that there is no adequacy decision. That means that the UK, even for transfer of personal data, is considered a third country, just like any other country, like the United States. And we saw what happened with the Privacy Shield being invalidated and things like that. So you have to put some additional measures. So the basic principle is that you cannot transfer personal data outside the EU to companies or other individuals unless you can provide adequate protection to that personal data. So protection that's almost equivalent to, or should be equivalent to, how you're protecting that data here in the EU. So how do you do that? If it's an adequacy decision, it's done for you. That means that the European Commission has decided that, you know, the UK affords or grants this protection sufficiently and in a way that's almost comparable to the EU, so you can transfer freely. However, If that's not the case, then you have to take additional measures. So it's your responsibility. And this is where it gets a little bit tricky. So what are these measures that you can put in place? Well, the first and most used measure is what we call the standard contractual clauses, the SCCs. Now, they were issued by the European Commission. It's basically, it's a contract that all the clauses are all filled in. You just have to put in the, you know, the company name of whom you're transferring to. So outside in which country and things like that. And now they've been revised. So a new version just came out on the 4th of June. They're going to become applicable as of the 27th of June. And then you have a transition period of 18 months. So for 3 months, you can continue to use either the old or the new ones until 27th of September. And then as 27th of September until the 22nd of December, 2022, you have to use the new version. Well, it's a transition period and you should only use the new version, but as of that date, you can't even have the old version in place anymore. So you have to replace them. Then you also have what we call the binding corporate rules. So that's only valid between companies of the same group. So it's not necessarily very useful, and it takes almost a year sometimes to get an approval from the European Commission. So that's only if you're part of a group. Then you have other derogations. So by Article 49, and this is, for example, explicit consent. This is something that's used. So you have to get, you know, you're going to transfer somebody's personal data. They have to give you explicit consent, not implied consent. You can't like think, oh, they're not going to mind. You really have to get and show that you received their consent. Then things like performance of a contract, and you can see the list is you know, rather short, but gives you some leeway to find some solutions in there, but it's important to, we won't go through them in detail. But if you look at that and see, you know, what am I transferring? Can I use one of these derogations to transfer data? Then yes. If not, then you get to the part, which are the, Romane, next slide, please.
I'm sorry.
Yeah. Where none of these exemption works, then you can transfer data, but really just, you know, on under very strict conditions. Can't be repetitive in nature. You can only send it, you know, regarding a limited number of individuals, and you have to make sure that you make a test to see if, you know, you have this overriding legitimate interest to transfer that data. So it's a tedious exercise, but you really have to look into it, because this is something that the data protection authorities now are really, you know, focusing on to see, you know, we've seen, I don't know, you probably are familiar with this Privacy Shield and Schrems 2 European Court decision, where all transfers of personal data now to the States, it's really difficult to do that. And so the authorities are looking at companies, actively sending out questionnaires, actively investigating to see where are you sending data outside of the EU, and how are you doing that, and are you doing that legally? And fines are really being imposed now. So very important that you look into this. I think, Romane, for you now, it's
maybe Jane.
Yes.
Maybe I saw that 3 questions came in.
Okay, did not see that. Hold on.
Yeah, I can't.
So the first question is, what happened in case of remote work?
If I have an employee working remote from the UK or other non-EU, and this employer works with personal data of clients like emails, how should this situation be treated? So I assume that what happens, or non-other, so this is, your company is in the EU and you have somebody in the UK. So that person, that employee in the UK is treating from non-EU clients, is that it? Remote where, and this employee works with personal data of clients like emails, yeah. Well, they're out in, whether it's remote work or not, if they're tied to your company, you're the one that's responsible. You're in the EU, there's personal data in the UK that's also being treated. There are 2 things to look at. Will you need to look at the data transfer? So for now, it's okay. So that I assume that the person in the employee in the UK is transferring data back to the EU, because that's where your company is located. So transfer, we said, from the UK to the EU, no problem. Even after the 30th of June, no problem at all. However, if you're transferring data back to that employee, or that data or other data, then you have to look at, you know, whether you have the appropriate measures in place after June 30th if you don't have an adequacy decision. And then if you're, Yeah.
Jasmine, sorry, what I actually wanted to say regarding this question, you
Yeah.
know that now it's very modern to work from another country. I mean,
Yeah.
a lot of employees from IT, from all kinds of services, they are working from other countries, not from the home country, let's say.
Yeah.
And when I'm saying that they process personal information, I'm saying that they still communicate with clients from Costa Rica. I mean, they are working from Costa Rica or from UK or whatever, and they are just sending emails.
Yeah.
Does it apply to you? Because the servers that they are connecting there are from
Absolutely.
that country, right?
Absolutely.
So they should have different or specific GDPR rules put in place for such work, let's say, right?
Yeah, the question you always have to ask is, where is the data flowing from and to? So if that person is working in Costa Rica, that's a non-EU country. And if they're working there and they're not even touching EU personal data, that's fine. However, if you're transferring data from their clients in the EU and they're accessing a database that's here and they're using a server in Costa Rica, the data is being transferred. And that's the tricky part, because you have to make sure that you're doing it legally. The principle is you cannot transfer data outside the EU, personal data, unless you have, an adequate measure in place. So look at how this is being treated. And if it's Costa Rica, there's no adequacy decision. So you have to make sure that, you use one of the other measures that we've seen.
Then
right.
there is what qualifies as personal data.
Yeah, only name of client qualifies personally, or is there a minimum volume details, which is nationality made? That's a very good question, Manuela. And of course, they were very broad in their definition in GDPR. So if you look, it's any information that identifies a person or can identify a person. So it goes as far as an IP address. So that's why they say if you monitor the behavior of people and things like that, you fall under the GDPR also, and you need to appoint a representative, is because if you're collecting statistics, an IP address from an internet source from your website, and you're doing that collection, the IP address could identify a person, even if you have to take extra steps, as long as those extra steps are not, they're not really technically feasible. But so it's very, very broad. So it is email, because you were saying you're giving personal nationality, email address, phone number. It's all that, but even one piece of that, and whatever the volume. So it's really, as long as you have that. So that's why we're saying it applies also to B2B situations, because you may just have the email address of somebody, even if it's their professional email address, as long as their name appears in the email, in the address, then it identifies them, puff, it's personal data. So it's very, very broad. Then I see, when you speak about EU, does it include the European Economic? Yes, it does. The European Economic Area. So it's Norway, Iceland, and Liechtenstein. That includes them also. So any transfer to those countries is okay, because it's like if they were considered in the European Union for GDPR purposes. So it does that. It does confirm. Thank you. Very, very insightful. Thank you, Manuela.
All right. So I think, yep, no more questions, but we'll go back to questions in any ways if you have some more. But just a quick, go back to adequacy decision. The procedure, as Jane said, is really important to know what's happening right now with this adequacy decision, and what it is really. So again, as Jane said, it's a decision by the European Commission that says that a country is recognized as having a level of protection that is adequate for Europe. So that's almost equivalent to the European data protection regulations. So this is the adequacy decision. Now, the procedure is really simple. Actually, you can see here the quick steps. So there needs to be a draft decision by the Commission, then an opinion by the EDPB, which is non-binding. Then the decision needs to be approved by the representatives of the EU member states. And this is when the decision is binding. And then the decision of the adequacy is adopted by the Commission. Now, it's worth noting that at any time, the Parliament and the Council can request the Commission to amend or to redraft or to withdraw even the adequacy decision if they have anything to say about it. So where do we stand now regarding the UK adequacy decisions? Well, as you can see on the slide, in February, so this year in February, the Commission issued the draft, and they said that the UK, they found the UK to be adequate. Then in April, the EDPB, as we said, is the second step. So the EDPB adopted 2 opinions, non-binding. And at this point already, the EDPB said that improvements were necessary on the adequacy decision suggested by the Commission. So they said that they didn't find it quite adequate. Now in May this year again, so the LIBE committee issued a resolution that evaluated the Commission's approach, and they agreed with the EDPB concerns. So they also said that the Commission needed to amend the decision because the UK couldn't be found adequate. Now in May, so 20th of May, the Parliament, as we said, the Parliament stepped in and they voted in favor of the resolution to amend. So they agreed with the idea that the decision needs to be amended, that the UK can't be considered adequate as of now. And the next day they confirmed this because they voted no to the non-amended version. So they just confirmed saying, we don't want to vote on this non-amended version. So at this point, we're just waiting to see what happens. And the deadline is very soon. It's 30th of June. And we're waiting for a decision of the representatives. So there has been, I think, the 2 past Fridays, there have been committees and meetings of the representatives of the member states to kind of discuss this. So it's ongoing, but there's still no solution. So we're just waiting. I'm also guessing the Commission will have to amend the draft because the different bodies insisted that it should be amended. So yeah, we're just waiting to see what's going on. It's really important to keep yourself updated of these developments because, as we said, it's very soon, and it's gonna impact your situation if you're gonna need to put extra safeguards in place or not. So yeah, back to you, Jane, regarding
So again, just to recap, what's going to happen after June 30th. If there's an adequacy decision, you're fine, business as usual. If there's not, then you have to put some stuff in place. Keep in mind also that even if it is approved, an adequacy decision only is granted for 4 years. So it's always up for renewal. So things may change also after 4 years. So it's really good to already think about those, different measures that you could put in place, have them ready, because you have gone through the exercise of thinking about it. If something happens, we've seen with the Privacy Shield, nobody expected that it would be invalidated by the court, and it was. And so if you didn't have a B plan, you were kind of, in trouble, which is the case for most companies anyway. And so make sure that this doesn't happen for the UK. Always have a B plan in place. All right. And we saw what were the most common misunderstandings with respect to data transfers. Now, what's the most common misunderstanding with respect to the adequacy decision is that you still need to appoint a representative. And this, we can't repeat it enough because we've said it before, even if there's an adequacy decision. So we're not talking about whether there's transfer of data or whatever, is that, there are 12 countries today that have adequacy decisions. Canada, Japan, Israel, so the whole list. That's not many countries, but it's still 12. So even those countries, so you can send data freely to them without any additional measures to be put in place. And those countries, you still need to appoint, companies located in those countries still need to appoint a representative in the EU or the UK, even if they have an adequacy decision. This will also be the case with the UK. So if you do business with the UK, so if you're offering products or services to people in the UK, or you monitor the behavior of people in the UK, you will still need to appoint a representative in the UK, whether or not there is an adequacy decision. And if there's one takeaway from this, this is something you have to really keep in mind, because the two are 2 separate obligations, or 2 separate elements, if you like. Okay, so tips to prepare your company for the 30th of June. First thing is really, like we said earlier, look at what's happening in your company, map all the data processing flows. So where is it going? And not just to the UK or whatever, it's just what is happening, where is your data leaving outside of the EU or not? But it's hard to imagine any companies not, sending data outside of the EU, for example, in the United States, if you're using Microsoft, if you're using, Google Drive and things like that, that means you're transferring data outside of the EU. So you need to identify where that data is going and make sure that for each country where that's going, what are the measures that you can put in place? You have to, so whether in their contracts, amend some contracts. If there is standard contractual clauses, you have to look at the new ones and make sure that you have the new ones in place in maximum 18 months. You have to specify in your documentation where you're transferring the data and what kind of documentation. Well, that's going to be also in your contracts, but it's mainly also in your privacy policy on your website. Make sure you update your privacy policy to say, are we transferring or not data, excuse me, to the UK, in this case, because we're talking Brexit, but also to any other countries, and make sure that you inform the individuals of what happens to that data, where's it going, and what measures you've put in place. Again, appoint a representative in the UK or in the EU. If you're a Moldovan company, it's going to be UK and EU. And yeah, I think we've covered that. Oh man, we can already, you were right on track. So there, so it's really deep dive. Look at what you have, look at your apps, look at everything you're using for your accounting, your customer relationships, your marketing. Are you using MailChimp? Are you using ActiveCampaign? Are you using something that's American based or UK based or something? Make sure that GDPR is about accountability. You just have to show that you've taken the time to look at, everything, your activities in terms of personal data and demonstrate. So you have to think, what if a data protection authority would come knocking at our door? What do I have to show that I've done what's necessary, or that you've done what you could do with the, the type of business that you have? Will that be sufficient? Can you prove that you've tried to respect all the principles of GDPR, especially regarding data transfers and the appointment of a representative? You have to show, really on paper, what have you done to be compliant? So that's, the first important thing that you should do. All right, so let's open up to questions. I know we've had a few already. If you want also maybe turn on your mic or your video, if you like that, because it's more personal. And maybe personal,
I have a question. In fact, I have a question.
Yes.
Which impact it will have on the e-commerce from and to the UK?
It's the same thing. So if you're from into the UK, so if you're in the EU, e-commerce is online business, right? So you're offering products or services. Where are you offering them? Are you offering them to people in the UK? Then you fall under the extraterritorial scope, because you're really targeting people located in the UK, and then you have to have a representative there. Same thing if you're in the UK and your e-commerce is also open to people in the EU, because they're two huge partners. The UK was part of the EU, so business continues as it was before, and there's a huge amount of business. So that's those are the questions you have to ask. Am I offering products or services to people in the EU and or the UK? Am I monitoring the behavior? So am I collecting statistics through cookies on my website and things like that? If the answer to that is yes, unless you fall under the exceptions, you have to appoint a representative.
Okay, thank you.
Yeah. So it's two different things, because people sometimes get confused. We're talking about transfers and representatives. So two different things. And these are the two aspects that we're talking about today, because they're part of the Brexit impact. So they're international data transfers. So transferring data outside of the EU, that's one topic. It has nothing to do if you're offering products or services. You just have to see, am I transferring personal data, and how am I doing that? And then the second topic is, do I need a representative? And the questions you need to ask is about offering products or services or monitoring the behavior.
Thank you, Jane. We have within our board of directors of the chamber also a lawyer, a Romanian lawyer. And I want to ask George if it was for him crystal clear and it was known to you, or you have other ideas about this procedures that what will take place on the 1st of July?
No, actually for me it's clear. Very good presentation.
Thank you.
Yes, also we are involved in this activity. So yes, thank you for the presentation. Congrats. Nothing to add.
Okay, thank you, George.
Thank you, George. Feel free to reach out, George, if you want to discuss this more. We're a
Thank
bit
you.
nerdy about this. We love talking about it, so don't hesitate to call us.
So
All
I
right.
would like
So
to
everyone's-
ask the audience if you have other questions.
Nope.
Manuela? No?
Yes, I might have actually. Just a
Yes.
second. Let me remove my mask and present myself in whole. Just a second. Thank you, Jane, for the presentation. It was really interesting. And
Thank you. And Romane, thank you too.
actually, for me, it's very interesting to see the GDPR in the context of the new trends of remote working and of the whole context of remote working, because I'm studying it a lot for the first half of this year, and I have seen that companies are not quite aware of the severe implications in terms of taxation, creation of permanent establishments, personal taxation, social security taxation. And actually GDPR just skipped my mind, and it's very interesting to see.
You're not the only one, Manuela. It skipped there everybody's mind.
So
basically.
thank you for adding to the whole picture. Because I have followed many HR business partners, HR directors pointing at, let's say, new policies. But I see that indeed there is a lot of work to do on that, and it needs to be added to the package.
Absolutely. It's good that you point that out. And if you can spread the word to make sure that companies, look into that so that they don't have to be, that they don't fall under the radar of data authorities in terms of GDPR compliance.
Now that you mentioned the IP tracking, some of the big companies that face the situations where employees just, we are working remotely, we just go to Greece and work from there. Nobody will know what we are doing from the hotel room.
Absolutely.
And so you can discuss about IP tracking. And again, it becomes interesting. It was interesting understand what is the nature of the personal data, because IP tracking is one of the tools which some of the big companies are trying to use in order to locate their employees. Yeah, because they can create permanent establishments, and that's it's a disaster. It can be a disaster. Thank you so much, Jane. Very interesting.
Thank you, Manuela. Lovely to meet you.
Absolutely, likewise.
Thank you.
I think, Jane, we can also share the presentation between the participants.
Yes, of course, no problem.
You can send it to me then I will make sure to Elena, and then we can share it with the participants.
Super.
If there are no other questions, we are within the frame of 1 hour, so it's perfect for everyone. We can go to for the lunch or for the next meeting. Jane, Roman, thank you very much. From my side, I would like to add that next week, Wednesday, the 23rd of June, we organize our first live event, really live event. So together with the Italian Chamber of Commerce, everyone is welcome in the Taverna Waterloo in Bucharest. Jane, Rowan, you want to add something?
Just thank you. It was lovely meeting you all, and please feel free and free of charge to contact us anytime if you want to just pick our brains on your specific situations, and we'll be very happy to help you out.
Thank you.
Thank you very much.
Thank you. Bye-bye.
Hello. Bye, everyone.
Bye. Take
Bye.
care.
Thank you. Bye-bye.